Hello guys, Svetlana Shlopak, the founder of UKVisaSuccess.com is here. I've created another video about the UK's new points immigration system, and in today's video we are going to cover the main principles of this immigration system. We are going to talk about the sponsorship requirements and the radical changes which the Home Office introduced in order to dramatically reduce consideration time. We'll also cover the skills charge, as well as we'll talk about the rights of dependents, the English language requirements, and I'll finalize today's video by explaining general rules about deportation and criminality. So let us begin.
Guys, and so that you know, this video is a part of the UK's new points-based immigration system video series. If when watching a video or reading an article which I publish on a weekly basis at UKVisaSuccess.com, you are at the point where you would like to know more information, you're very welcome to go to UKVisaSuccess.com/new PBS, where PBS stands for points-based system, and request this information. It is completely free, and the information will be with you within the next 60 seconds. In this video series, we'll cover a number of topics. We'll talk about work, study, and visits related immigration routes, which are all part of the UK's new points-based immigration system. We'll talk about skilled workers, health and care sector visas, as well as Appendix W categories, including a global talent, startup and innovator categories. We'll also cover the UK's immigration routes which were created for students. We'll talk about the existing Tier 4 route and the newly created, or rather the old and forgotten graduate route, which will allow students to remain in the UK after their studies in order to work in the UK. And finally, in this video series, we'll have a number of videos dedicated to other routes which are not part of the new UK's points-based immigration system, but do allow migrants to work in the UK. Okay, and now let us begin this video by talking about sponsorship. Certain new and existing points-based immigration routes will need to have sponsors. These requirements will apply to the skilled worker routes and the health and care routes, as well as the student routes and some specialized worker routes. All the specific requirements will vary. The general idea behind immigration sponsorship is to ensure that the sponsor prove their credibility to the Home Office. They will need to undergo certain checks to determine that they are a genuine business, they are solvent, and the role they wish to recruit migrants into are credible. And the salary and the skills requirements will need to meet certain requirements as well. Once they've proven this, they will get a license from the Home Office. They will need to pay a fee for this, and some sponsors will also need to pay immigration skills charge. It is to ensure that their mission benefits and is conducive to the wider public good. All senior personnel and key users who are part of the sponsorship program will need to undergo criminality and other security checks. And it will directly affect the sponsors, which are educational institutions. They will need to hold what is known as the basic compliance assessment. When the Home Office carries out a basic compliance assessment, it will assess the sponsor against the core requirements. The core requirements are that the sponsor needs to have a visa refusal rate of less than 10%, an enrollment rate of at least 90%, and a course completion rate of at least 85%. And they will also need to undergo additional scrutiny if they wish to teach children. The Home Office has introduced many radical changes to its current sponsorship process. They intend to make the process more efficient, more effective by employing faster and simpler working methods. Most importantly, the new sponsorship process will help the sponsors to bring the migrants much faster. The Home Office will suspend the cap on Tier 2 general applications. Tier 2 general is the route for non-British citizens, skilled workers to enter the UK. And also the Home Office will remove the resident labour market test. This is when the sponsor needs to advertise the job position for at least 1 calendar month before they could invite a worker from outside the UK. These two measures alone, removing the limits from the number of the applicants who may apply and removing the resident labour market test, should reduce the application process by at least 8 weeks in comparison to the existing process. Okay, so what about sponsors' licenses for the new skilled worker routes? First of all, it is important to begin by saying that existing Tier 2 general and Tier 2 intra-company transfer sponsors will automatically get a new skilled worker license or intra-company transfer license if it is the Tier 2 intra-company transfer route. Their license will expire when their current licenses expire. The Home Office will get them the relevant number of certificates of sponsorships. Secondly, as under the new system, the new skilled worker route sponsors will not be concerned with meeting the residence labour market test. They will need to make sure that they provide the Home Office with enough evidence to prove that the vacancy for the migrant in question is a genuine one. And also they will need to pay the appropriate salary and they will need to meet the necessary skills. Guys, in case you wonder what appropriate salary is, this is where you can find out. Just request this information by going to ukvisasuccess.com/new PBS and all the information will be there. I've downloaded a number of tables for you just to make sure that you have a general idea as to what the appropriate salary is. Also, the sponsors will need to prove that the migrant in question will meet the necessary skill test. It is to ensure that the sponsors do not create jobs solely to help a specific person to enter the UK. Thirdly, the sponsors will need to pay the immigration skills charge unless exemptions apply. The fees are £1,000 per worker for the first 12 months. Then it will be £500 for each subsequent 6 months period, and charities and small and medium enterprises will need to pay only a reduced fee of £364 per worker per year. There will be no difference in fees for EU and non-EU workers after 31st of December 2020. Well, the next one to consider is the English language requirements. You'll find these particular requirements in almost every UK's new points-based immigration system. However, the level of English language may vary. For example, the degree level students will need to have the ability to speak English at the level of at least B2 of the Common European Framework of Reference, which is the equivalent of A level, and it will be slightly lower for the skilled workers. It will be a B1, which is AS level equivalent. Also, the Home Office will be slightly more flexible in allowing the migrants to meet in the English language requirements. For example, doctors, dentists, nurses, midwives can get a confirmation from their professional bodies that they can speak English at the appropriate level. And also, the Home Office will extend the list of majority English-speaking countries to include Ireland and Malta. I also promised to talk about dependents. There will be no change in respect of dependents, partners and dependent children under the age of 18. Of skilled workers and postgraduate students can accompany their relatives to the UK. They can work full-time and children can access a state education. They will need to pay the immigration health surcharge as before. Most importantly, in the definition of partners, the Home Office included civil and unmarried partners in durable relationship. With regards to switching is the legal term which allows migrants to change their immigration categories when already in the UK. The majority of UK's new points-based immigration routes will allow this switching. Unsurprisingly, those who want to switch will need to demonstrate that they meet all the requirements for the new immigration routes, and also, as before, those who are on short-term routes in the UK will not be able to switch. And these categories include visitors and seasonal workers. So these guys, visitors and seasonal workers, will not be unfortunately able to switch. To finalize today's video, I would like to talk about criminality and deportation. After 31st of December 2020, the EU citizens and non-EU citizens will become completely equal as far as the criminality and deportation rules are concerned, unless they're protected by the withdrawal agreement. As was the case with all visa national migrants before, now the Home Office will apply the rules equally to EU and non-EU citizens, and will refuse visa applications if a person has a conviction with a custodial sentence which is for more than 12 months, or they've committed an offense which caused serious harm, or they are a persistent offender who shows a particular disregard for the law. If a person is already in the UK and they were convicted for more than 12 months, they are most likely to be deported from the UK. If their sentence is for less than 12 months, the UK immigration authorities can still deport this person if it is conducive to the public good, including where they have serious or persistent criminality. Also, where their character, conduct and associations means their presence is not conducive to the public good. And this is it, my friends. This is all we wanted to discuss in this video. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law, and also I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you are subscribed to this newsletter. Have an amazing week, guys.